We all want people treated fairly, don't we? That's why Congress passed the Americans with Disabilities Act. But what's the real result? When the politicians passed the ADA, they thought about the blind, deaf, people in wheelchairs. But today, most disability complaints are not filed by those people, but by people with back pain. That's number one. Then sore joints. Then people suffering from depression. Then all kinds of things like stuttering, which I mentioned earlier. I'm a stutterer, so if Fox fires me because I do a lousy job on this show, can I sue them for not accommodating my disability? Your Honor, if only they had accommodated me. Sounds ridiculous, but the ADA encourages lawsuits like that. And joining us again is Kurt Decker of the Disability Rights Network, and also Walter Olson, who writes the wonderful blog Overlawyered.com. Overlawyered says it well, and when I read his blog, I get furious about how some lawyers rip us off. But, Walter, let's just focus on the disability lawsuits. So, in some states, disabled people can make thousands of dollars for themselves by going from business to business and searching out little violations. And some lawyers will meet one shortly, say, that's a good thing. He's getting rich off that.
And it turns it into an industry where you march someone up and down a main street, and before long you have lawsuits worth thousands of dollars apiece against all the little mom-and-pop businesses.
So what? Those businesses were violating a 20-year-old law they should know by now.
Well, that's what you will hear from the lawyers, but it is so bewildering to one of these businesses who, even if they go and ask, what should I do to be in compliance, they will get 10 different answers from 10 different people. And so you can find some violation and you can make money against them.
Yeah, Kurt.
Well, first of all, let me tell you that you're absolutely right. They are out of compliance. These are not frivolous lawsuits. These are clearly violations. And I don't know what's clear about not getting rid of a step. What comes into the courts are the bad cases, the strange cases, the cases where the employer or the other side will say, no, we're not giving into this. And so as a result, you see the back pain cases. The majority of cases are settled without anyone ever hearing about it, and that's what the beauty is. It's a preventive law. It prevents lawsuits, and the ones that do actually get made are the ones that end up getting the press.
It's a beautiful law.
They are settled without anyone hearing about it because the business is terrified to resist. To me, it's not just about... I want people to be terrified about discrimination. I want people to be terrified about discriminating against people. When every small business on the street is getting sued and everyone is forking over $5,000 to the lawyer, is it just the bad eggs at that point?
Well, not everyone is forking over $5,000. Most accommodations are inexpensive and easily done. But there are, as
you know, it's not just
some lawyers who are taking advantage of people.
Right. It's not just paying to move the paper towel rack, it's also paying the lawyer $5,000 to drop the case.
No court would ever award the attorney's fees if they pursued it. There's no question that any statute...
Well, I'm sorry, what was that? No court? Courts almost never don't give the lawyers
These
money.
cases never go to court. These cases get settled.
The lawyers always get their money.
The defendant will pay the attorney's fees. But if they carried it into court, a judge, if you have fixed the violation, no court would ever rule against you, number one, or charge you attorney's fees.
You're still out thousands of bucks.
To make your restaurant or your service accessible, which is what the law requires.
And I disagree because, in fact, when they do fix the thing, they still owe the attorney's fees, which will be much larger in many cases than what they spent to fix the toilet stall or whatever.
Kurt, let me just ask you that there's a lot of stuff in here, and some of it is what you're allowed to ask in a job interview.
Correct.
So I come into the job interview with you. My arm is in a sling. Are you allowed to ask me, why is your arm in a sling?
No, I'm not. I'm interested in...
Why is that good?
Well, why do I need to know why your arm is in a sling? I need to know that you can do the job that I am hiring you for. I'm curious about a lot of things, but it isn't my right to ask you. I'm employing you to do a particular job, and I need to know that you can do that job. And by the way, the ADA says the person has to do the essential functions of the job. So in your situation... One, I would agree, you are a person with a disability. Two, you are protected by the ADA. But three, you would have, and I would suggest that if your employer did try to fire you for your stuttering, you'd want the protections of that. Now, the question is, can you do the essential
they ought to be able to, if I can't host this show without annoying people with my stuttering, they ought to be able to fire me.
Possibly, if they decide that stuttering is part of the essential function of the job, they could. But why should they? Why can't you retape the show? Why can't Americans listen to a person who has a slight stutter and still get the news and learn about what's going on in this country?
Let's put those questions up on the screen that you're not allowed to ask. Does chill speech? It
does not chill speech. We are looking at the person's abilities, and we're looking to see whether they can do the job. If the person needs an accommodation because of the disability, they must tell their employer that they have a disability, and they must ask for the accommodation. An employer does not have to guess whether someone needs an accommodation and cannot be sued for not providing that accommodation. So there is a burden on the person with a disability to say, now that you've offered me this job, I need to tell you that in order to do this job, I need the following accommodation. And the employer can say, that's too expensive, I can't do that.
You wait until the job offer has been made, at which point you put on the table that you're going to be a very expensive person to accommodate. That's the way it's set up.
Possibly.
You can hide the disability until...
Expensive. I want my desk raised. I want to be told...
Isn't the fact that 10% fewer disabled people are employed proof that this has done more harm than good?
And there's not a bit of proof. It's proof that we have a serious problem of unemployment with people with disabilities. I am not happy, and none of my colleagues are, about the failure of businesses in this country to understand the potential workforce that they have with people with disabilities.
How about the bigger failures since your law passed?
Well, again, I don't think there's any proof that the unemployment rates with people with disabilities comes from the ADA. I think it has to do, again, with stigma, the feeling of what people...
But stigma was there before.
That's right, and we are going a long way to do by having people in our lives every day with a disability begins to break away around that stigma that has been inherent in this country for hundreds of years.
We have fewer people in our lives in the workplace because of the drop in participation by the disabled. So things seem to be running in the wrong direction.
Well, we have fewer people in the workforce generally.
We need to continue this. Thank you, Kurt Decker. Walter, please stay with us, because when we return, one of those evil, rich lawyers I mentioned earlier. He runs what Walter would call a lawsuit filing mill, and he's sued more than 1,000 businesses. I'll confront him when we come back. Everyone wants to protect disabled people. And the ADA, the Americans with Disabilities Act, was supposed to do that. But with such laws come complicated regulations and lawyers and lawsuits. And lawsuits are so expensive, they often kill good things.
Basketball Town was a special events facility for basketball, volleyball, various sporting events where kids and families could come and spend time after school and on the weekends in a positive athletic environment.
But then a boy booked a birthday party. They scheduled it upstairs. One guest showed up in a wheelchair.
We actually offered to move the party downstairs, and they declined. And as a result, months later, we were served with a lawsuit.
Basketball Town was eventually dropped from the lawsuit, but they still had to pay lawyers $100,000.
Finally, as a result of all the legal fees associated with the lawsuit, we had no choice but to close the facility.
So no more Basketball Town. And I don't know how many other places were shut down or maybe never open because of fear of disability lawsuits. Returning with us now is Walter Olson from the Cato Institute, who works on legal matters, and also Tom Frankovich. Frankovich is a lawyer who files lots of disability lawsuits. He didn't sue Basketball Town, but he sued maybe 2,000 places?
Probably.
Made a lot of money?
I have.
You have a bison ranch and a home, beautiful home in an expensive town overlooking a bay from these lawsuits.
I do.
You're making good money off them. Why is that good?
We're not the Walmart of lawyering. We're the Neiman Marcus. And the situation is, if you're going to have someone that's going to take on and represent the disabled, you need to have a good lawyer to be able to do that. And my firm is good at what we do.
I have no doubt that I believe that you're good at what you do, but aren't you bad for America?
No, not at all, because I think what people don't understand is that the people that can go ahead and make the difference to provide access and not have litigation are the landlords and the tenants. They have a continuing obligation under the ADA to look at their facilities and make a determination is there anything that we can do to make it more accessible.
They're trying to run a business. They're trying not to poison their customers with the food. They're trying to lure people in, and they have to read this thick law or hire one of your brethren to do it?
John, can I jump in with a question? Before you sue them, do you let the business know that you found a violation and give them a chance to change it?
That's a good point. Under the ADA, there's no notice requirement. However, our firm, in order to take on a case, it has to meet our criteria. And the criteria isn't just one violation, but multiple violations. Further,
so you will say to them, hey, you got this problem, fix it, and we won't sue?
Every one of our clients, before we'll
give me a yes or no to that?
The answer is yes, we will not sue.
Many of your colleagues don't give people that chance, right? They just sue. Extort some settlement money.
Well, it's not a question of extortion. You got to go back to the situation. No, you have to go back to the situation where the ADA provided that you have to provide access if it's readily achievable, which means without great difficulty or expense. Now, you know, the great difficulty, and when you show that document, how thick it is, I would tell anyone and tell your viewers, you look at the Code of Federal Regulations, 36.304 A and B and C, and that's only about 3 pages, and that about gives you everything you need to know to at least start removing barriers.
Start, but not finish. There's always going to be something else. And you speak as if it's easy to comply. You know about all of the California restaurants that have gone out of business. You know, I document them on Overlawyered. We have a regular sort of roll of them. This is not an easy law and not a cheap law to comply with.
In California, your state is a little unique. This is where you operate. California lets disabled people be, in effect, bounty hunters. Every violation they bring to you, they can make up to $4,000, and I think that's an invitation to abuse. Here's one example. Ron Piazza saved his money and bought a fast food restaurant. Then
I received a call from an attorney about 4 months ago that indicated that I was being sued for an ADA lawsuit. After being served, I learned the reason the plaintiffs came to the restaurant so often was because there's a certain dollar amount associated with each visit. And had I not lowered the mirror, they probably would have continued to come. It would have been very easy for them to let us know that the mirror was a couple of inches too high, and we could have taken care of that right away.
Instead, he says, hiring lawyers and fighting the lawsuit is costing him more than his restaurant made last year. This is why I call these suits extortion.
Well, I would agree with you if it was just a situation where it was a single mirror, a single violation. But in the majority of lawsuits, you'll find that it goes back to a variety of different violations. The parking, the seating, the failure to wrap the pipes, the failure to put grab bars in, the failure to make the partition big enough.
Do you agree that your lawsuits, which have done well by you, cost America money, have some bad consequences, or it's all good?
No, I think it's all good, because I think you have to look at it, especially in California, where we have punitive statutes. That's why there's $4,000 on the Unruh Civil Rights Act, and under the Disabled Persons Act, $1,000, because it's been shown that only the hammer of litigation makes the changes.
And what about the unintended consequences? Kindles were offered in some colleges because they're much cheaper than textbooks. The Justice Department steps in and says, can't use them, unfair to blind people.
Well, you know, that's not an area that I practice in, so I'm not...
Okay, one more. A doctor,
in a situation of
a deaf patient went to a doctor and wanted a sign language interpreter. It would cost $150 to $200 per visit. He only is reimbursed $50 a visit. He saw her 20 times for lupus, and she sued. And he communicated through her daughter and through writing things down. She sued. A jury awarded $400,000 in damages. He has to lose money to treat her?
It's a situation where society has to take care of one another. And in this instance, if you're going to make the accommodation, and I'm not familiar with this particular case, you would have to bring somebody in that could do that for that patient. Otherwise, who's going to be able to treat the patient if it's going to?
He was treating her. He was just writing it down.
To have sign language.
And the word from Washington is that that case is the bellwether for everyone else. The guidance from the federal government is that, yes, that doctor getting a $50 Medicaid reimbursement has to pay for that interpreter for more than $100. It's crazy.
It sounds
I think
crazy.
The other thing here is that
we're out of time. I'm sorry. Thank you, Walter Olson of the Cato Institute and Overlawyer.com. Tom Frankovich, very successful trial attorney.